All right, let's get right into it. If you're tackling corporate law, you know that company meetings are where everything happens, the big, company-altering decisions. But here's the thing. What actually makes those decisions legally binding? You see, if you get this wrong, an entire resolution, a massive decision, can just be thrown out. So today, we are going to dissect the anatomy of a valid company meeting step by step. So let's start at the very beginning with the basic definition. A meeting is just a gathering to get lawful business done. Sounds simple, right? But look at that last part because it's absolutely crucial. There must be at least two people. Now, sure, the law has some super rare exceptions, but for 99.9% of cases, the rule is two. This really sets the stage for our main question. What are the exact legal ingredients that turn a casual get-together into a powerful, legally binding company meeting? To figure that out, we're going to use a really clear three-part blueprint. First, we'll look at what it means for a meeting to be duly convened. Think of that as sending out the invitation correctly. Then we'll cover properly constituted, which is all about having the right people in the room. And finally, properly conducted, following the rules of the game. Then we'll finish up with the official outcome, resolutions. Trust me, this structure is your ticket to nailing this topic. Okay, think of this as the absolute foundation of a house. Every single valid meeting has to stand on these three pillars. They are completely non-negotiable. If even one of them is shaky or just missing entirely, the whole thing can come crashing down, legally speaking. So here's the most important thing to get. These pillars build on each other. You can't just skip a step. You can't have a properly constituted meeting if it wasn't duly convened in the first place. And you definitely can't properly conduct a meeting if the right people aren't even there. If you mess up even one of these, any decision made could be completely worthless. So let's dig into that first pillar. Duly convened is all about the prep work. It's everything that has to happen before the meeting even begins. This is about making sure the meeting is legitimate from the very start, and it really comes down to two big questions. First off, who can even call a meeting? Who has the power to summon everyone? It's not a free-for-all. You can't just have anyone deciding to hold a meeting whenever they feel like it. It has to be called by a proper authority. An improperly called meeting is dead on arrival. It's invalid from the get-go. The law gives us three main options. The most common one, the default, is the board of directors. It's their job. But what if they refuse to act? Well, the law empowers the shareholders to actually force a meeting through a formal demand called requisition. And in really extreme situations, say there's a huge fight in the boardroom that the company is paralyzed, the tribunal can step in and order a meeting to happen. Now, even if the right people call the meeting, it means absolutely nothing without the single most critical piece of the puzzle, proper notice. And this isn't just about being polite. It is a strict legal requirement with very specific rules that, let's be honest, show up on exams all the time. Okay, this is a classic exam question, so let's really break it down. The law demands 21 clear days of notice. The term clear days is so important. It means you don't count the day the notice is sent, and you don't count the day of the meeting itself. On top of that, if you're sending the notice by mail, the law adds a presumed 48 hours for it to get there. So when you do the math, you actually need to send that notice about 25 days before the meeting to be safe. It's a perfect example of how detailed and precise the law can be. And who gets this all-important notice? Well, the list is pretty long. Of course, every single member. But it also has to go to the legal reps of any deceased or bankrupt members. And this is key. The company's auditors and every director have to get it too, plus the secretarial auditor. And here's a little legal detail you need to know. If you accidentally forget someone, it might not invalidate the meeting, but if you deliberately leave someone out, it absolutely would. Okay, so the meeting's been called by the right people, and the notice has been sent out correctly. People are starting to show up. Time to move to Pillar 2, which is all about what needs to be in place the second the meeting is supposed to start. This is all about setting the stage for a valid meeting. The first, and honestly most important element here is the quorum. Think of it as the minimum number of players needed to start a game. Its whole purpose is to stop a really small group of members from making huge decisions for the entire company. If you don't have a quorum, the meeting is a non-starter. You can't do any business. Period. The Companies Act lays out the exact numbers, and you've got to know them. For a private company, it's pretty simple. You just need 2 members there in person. For public companies, it's a sliding scale. 5 members if the company has up to 1,000 members. 15 if it's between 1 and 5,000. And for the big ones, over 5,000 members, you need 30 people. And notice the key words, personally present. Proxies, people sent on behalf of members, do not count for the quorum. So, what happens if people are running late or stuck in traffic? Well, the law is reasonable. It gives everyone a 30-minute grace period. But if that half hour passes and you still don't have enough people, the meeting can't go ahead. What happens next, though, depends entirely on who called the meeting.
And this is a really important distinction to remember. If the meeting was demanded by the shareholders, the requisitionists, and they don't show up to form a quorum, the meeting is just dissolved, canceled. It's over. Which makes sense, right? If the people who wanted the meeting don't even bother to come, the law isn't going to keep it going. For pretty much every other meeting, it's simply adjourned, usually to the same day, time, and place 1 week later.
All right, we called it correctly. We have a quorum. Now we finally get to Pillar 3, the main event itself. Being properly conducted just means you follow the rules of procedure to discuss business and, most importantly, to actually make decisions.
At its heart, this is how a company acts. A member stands up and proposes a motion, which is just a formal suggestion. Then all the members talk about it, debate it, and finally, they vote on it. If that motion gets enough votes to pass, it transforms into a resolution, and that is a formal, legally binding decision of the company.
So, how do you figure out what the meeting wants? The default way is a simple show of hands. In this case, it's one person, one vote. Doesn't matter if you own 1 share or 1,000,000. But that's not always fair, is it? So, members with a bigger stake can demand a poll. A poll is completely different. It's 1 share, 1 vote. This is where the power shifts to those who own more of the company. Of course, for bigger companies, electronic voting is now required, and for some really huge decisions, they might use a postal ballot.
And what if you can't make it to the meeting? You can appoint a proxy to go for you. But, and this is important, a proxy's rights are very limited. A proxy is not allowed to speak at the meeting, and critically, they can only vote when a poll is called, not on a show of hands. This makes perfect sense when you think about it. A show of hands is a vote by the individuals physically present, while a poll is a vote based on share value, which is what the proxy is there to represent.
So we followed all the rules, the votes are in, and a motion has passed. It's now officially a resolution. But not all resolutions are created equal. The law has different categories for them, based on how important they are and how much agreement you need to pass them. This is another one of those things you just have to know. The 2 big ones are ordinary and special resolutions. An ordinary resolution, or OR, is for your day-to-day routine stuff. It just needs a simple majority, more votes for than against. But a special resolution, an SR, is for the huge, game-changing decisions, like changing the company's rules. This needs a supermajority. The votes in favor have to be at least 3 times the votes against. That's a 75% threshold. And one more thing. The meeting notice has to specifically say that a special resolution is on the table to warn everyone that something big is up for discussion. And just when you think you have it all figured out, there's one more layer. Some really sensitive actions, like firing a director before their time is up, need what's called special notice. This basically means the members who want to propose it have to give the company an extra heads up, at least 14 days before the meeting, so the company has time to tell all the other members. It's an extra layer of protection for really controversial stuff. So, let's just quickly recap our blueprint. A valid meeting must be duly convened, the right people call it, with the right notice. It must be properly constituted. A quorum is there. And it has to be properly conducted. Decisions are made fairly by voting. If you nail all 3, you've got yourself a valid company meeting.
Okay, so you did everything perfectly. The meeting was flawless, but months down the line, there's a disagreement. How do you prove what was actually decided? You see, knowing the rules for holding the meeting is only half the battle. The other half is creating the official, legally recognized record of what went down. And that leads us to the vital topic of meeting minutes, the ultimate proof that it all happened.